We are in the throes of our license law and commission rules. So we're getting ready to pick back up where we left off. But before we continue, I just want to see if we have any questions about anything we talked about last night. I think it was a pretty good review of like material facts and the big four, the prohibited acts and material facts, and agency disclosure, agency agreements, all of those, 7, 8, 9, and 10 is going to be okay, as long as, yep. Going to be heavily tested units, 7, 8, 9, and 10. I think I told you guys once, I counted it up, and 7, 8, 9, and 10 accounts for like 40% of your exam. So make sure you're spending time in those units. Now, with that being said, that isn't all of your exam. So don't just be spending all of your time in 7, 8, 9, and 10. There's other units too. But those are good chunks. So welcome. So let's pick back up where we left off. And we had just finished talking about agency. We're still in general brokerage provisions. So the Real Estate Commission addresses prohibits a broker who's selling a property from representing the buyer in the same transaction. Let's talk about this. If I own a property and I list it for sale, real estate agents buy and sell properties all day, every day. So I could own a property and list it. I could represent myself. I could be the listing agent and the seller in the transaction. Do y'all think it's fair if I'm representing the buyer? Do you think that's fair for me to represent the buyer? No. Can we see that as a huge conflict of interest? I hope so, because Old Car says I have my client's best interest. But if it's my property that I'm selling, let's face it, whose best interest do I actually have? I have Julie's best interest, don't I? So other agents in the firm could work with the buyer, right? They could represent the buyer, but I can't. So if I could do my own open house, you come into my open house on Sunday and say, wow, this is nice, I want to write it up. I say, great, let me get you to an agent in my firm, they can help you out. Does that make sense to everybody? Kind of the same thing if you are the listing agent and you want to purchase the property. You're already representing the seller. If that event comes up, if that happens, then your BIC needs to have a conversation with the seller. They need to discuss with the seller, talk to the seller kind of about what, hey, your agent really likes your house and now they want to buy it. Give the seller the option to transfer to somebody else in the firm, or if they really, really don't like that, then the BIC may give them the option to terminate the listing. But the BIC needs to have a conversation with the seller. I actually had a listing once and it was so cute. Oh my goodness. And my husband and I, the night I listed it, we sat on a couch and looked at pictures and talked about whose room would be where. I mean, it was cute. So I came close to that scenario, but we ended up not buying it. But you're going to fall in love with some of your listings. So if you do move forward and want to buy it, just get your BIC involved so they can make sure their seller is best represented. The exception to the broker selling a property from representing the buyer in the same transaction, the exception is a commercial transaction. If you own commercial property, if you own less than 25%, you can be an owner, you can be the listing agent, and you can represent the buyer, as long as full disclosure to the buyer. Yes, I'm the listing agent in this commercial property, but I also own 24.5%. Let the buyer make that decision with full disclosure. Comments or questions on that? The Real Estate Commission has some rules, as you know. Once you're licensed, if you change your name, or if you change your address, if you change your contact information, we have to notify the Real Estate Commission of that change within 10 days. So once you guys get your license, when you go to ncrec.gov, you'll have a login, and that login will get you to your broker record. So if you get married or divorced and change your name, or if you move, change your phone number, email, you can go into your log on the Real Estate Commission's website and make that change. But you need to do it within 10 days of the change. 10 days. There are provisions about advertising. Remember, we said last night, we said in unit 7 and 8, I cannot do a single thing for an owner of a property without first having a written and signed agency agreement. May that be a listing agreement or a property management agreement. I cannot perform a single service for an owner without having a signed written agency agreement. And that includes advertising their property for sale or for rent. I kind of hope this goes without saying. You can't tell somebody everybody their home is for sale if you don't have an agency agreement. And one of the big responsibilities is the advertising that comes out of the firm. Remember, you guys, it's not your listing. Whose listing is it? It's the firm's. So if you're promoting your services on behalf of the firm, if you're advertising a listing on behalf of the firm, your BIC should review it before it's published. We know how quickly social media can spread, right? You hit submit and it's out there. And I'm telling you, once it's out there, it's really hard to get back. So have your BIC review it before you put it out there, whatever platform of advertising you're going to use. Provisional brokers especially, but also full brokers, the BIC is responsible. The BIC's going to be looking for various things. Make sure the firm's name is there, make sure the firm's contact information is there. They want to make sure that there's no violations of fair housing, for example. And the BIC is also going to want to make sure the firm has its brand identity. So a brand identity, people should be able to look at your firm's logo and know that it's your firm. Think the golden arches. As soon as you see those golden arches in that McDonald's brand identity, and they use that certain color, it's a certain shade of gold. So your firm's going to have an identity as well, and your BIC is going to want to review your advertising to make sure that you're properly representing the firm. And one thing that's not allowed, commission rule, our advertising cannot have blind ads. And a blind ad is one that does not include the identity of the firm. Why? Again, I ask you, whose listing is it? Who are you promoting services? It's not yours. So make sure when you advertise your listing, when you promote your services, you got to include the name of the firm that you're affiliated with. By the way, this does pertain to social media. We could stand here all night, debate. We're not going to, but we could stand here all night and debate about whether or not you should have a personal Facebook or should I have a business Facebook. We're not here to talk about that. I'll let your new firms, when you affiliate, handle that. But if you choose to advertise under your personal Facebook, that's fine, but you got to make sure you include your firm identity when you're promoting and advertising your services. Questions on that? There is a general brokerage provision on delivery of instruments. First off, let's talk about what the heck an instrument is. An instrument is just any document related to this transaction. It typically starts with our agency agreements. Somewhere down the road, we have our contract paperwork. And then eventually, fingers crossed, we're going to have closing docs. Every step of the process, anytime your people sign something, we have to deliver that, a copy to that, to them within 3 days. General rule of thumb, if they sign it, they deserve a copy of it. Seems fair, right? Some agents think, well, I'll just wait till the end of the transaction and send all the paperwork all at once. No, what does the rule say? We have a duty to deliver it within 3 days of execution, 3 days of sign. So they sign the agency agreement. It should not take you, it's as simple as sending an email with a PDF attachment. Hey there, here's our agency agreement. I look forward to working with you. Have a nice day. By the way, are you going to keep record of that sent email? Are you going to keep that in your transaction file that you sent it? Yep. Because what do we document? Everything. So if you go into your sent file and put it in your transaction, that transaction folder, you'll have record that you sent the agency agreement, that you sent the signed contract. The exception to this rules, aren't these fun? Exceptions to rules. The exception to this rule says that we have a duty to deliver all offers to sellers immediately, but in no event later than 3 days. When do you deliver offers to your sellers? Immediately, but in no event later than 3 days. This is the buyer's agent delivering an offer to the listing agent. This is also the buyer's agent communicating directly with the for sale by owner. What if you're a listing agent and you're already under contract? Your seller's under contract. We're halfway through due diligence and another offer comes in. Do you have to present that to your seller? Yeah. Because which ones do I present to my sellers? Every single one of them. What if that second offer is better than the contract? And your seller says, ooh, I want to terminate. Remind them they would be in breach. Remind them that the buyer could sue them. If they want more information, we may need to refer them to an attorney. Let the seller discuss with an attorney the consequences of breaching a contract. It may not be worth terminating this contract to accept this offer that's more money. We might have mentioned this. Let's see. Show me on your fingers. Does anybody know for how long we keep all of our records? Does anybody remember? We've mentioned this. Good. Retention of records. Real Estate Commission says we keep all records for 3 years. That 3-year clock starts from the successful or unsuccessful conclusion of the transaction. Listing agreement never goes under contract and expires. I keep that for 3 years. Go under contract, never makes it to closing. I keep that for 3 years. Goes to closing. I keep it for 3 years. The 3-year clock starts at the end of the transaction. If your firm has a trust account, and I know we got questions on trust account, we're getting there tonight. But if your firm maintains a trust account and the earnest money deposit's in dispute, the transaction's over, the firm's going to maintain the earnest money until the dispute is resolved. The conclusion of the transaction is whenever that earnest money dispute gets resolved. We might have terminated the contract 2 months ago, but we're still hanging on to that earnest money. So the conclusion of that transaction, for example, wouldn't end until that earnest money dispute. And again, we'll talk more about disputes and trust account and all that in just a bit. So we keep everything. Keep all of your advertising. Take screenshots of your Facebook post. Keep all of your marketing. You run something in the paper, run out on Sunday morning and pick up a paper to have for your transaction file. When you go to measure a house, keep your sketches that you measured, keep your graph paper, keep your calculations. It may look like chicken scratch to anybody else, and you're the only one that can interpret it, but it shows that you did the work. CMAs. Every time you pull a CMA for a seller or a buyer, keep those. Notes on a subway napkin. Keep everything for 3 years, at least. My firm uses a e-signatures program called Dot Loop. Your firm will have some kind of program as well. Ours is Dot Loop. Dot Loop keeps stuff for 10 years. That's part of what signed us up for that one, because we are well in compliance here. Thank you, Dot Loop. And cloud storage. I don't know what we're going to do when the cloud fills up, but I guess we'll cross that bridge when we get there. Brokerage fees and compensation. If you're going to make a bonus, maybe the builder is offering a $500 agent bonus for all accepted contracts written by the end of February. If you're going to make a $500 bonus, you have to disclose that to your buyer. Your buyer has a right to know that you're going to make more than the stated commission off of them. And we have a duty to disclose those bonuses in a full and timely manner, timely disclosure. This does not mean we're sitting at the settlement table and you say, oh yeah, when you sign in just a minute, I'm getting $500 extra. That's not timely disclosure. Timely disclosure is when your buyer's thinking about making an offer on that builder's home. The buyer needs to take that into consideration when they're considering their offer. Let's think this through. Let's just talk out loud for 1 second. We're all good in a typical transaction when the seller is represented. The seller pays the listing firm shares their commission with the selling firm. Everybody's good with that, right? Seller pays the listing firm shares their commission with the selling firm. If the builder, for example, is the seller and they're offering a $500 bonus, it's probably coming from the sales price. Yes, tack on the sales price, $500. Even though the seller's paying the commission, who's paying the sales price? The buyer. So that's why a buyer has the right to know that you're going to get a bonus, because they're the ones paying the sales price that commission is based off of. So full and timely disclosure on commissions, incentives. A couple restrictions, compensation disclosure. We don't have to disclose our commission, bonus, incentives to customers. This only applies to clients. And what we disclose is the firm's commission. It is nobody's business what my split is. So the firm gets paid and then they share their commission with me. It is nobody's business what my split of that firm's commission is. You do not disclose that. What we are disclosing is the firm's commission. And as we've been saying a couple times now, the real estate commission doesn't get involved with money. Commission, salary, fees, referral fees, bonuses, incentives, they don't get involved with matters of money.
Julie?
Mm-hmm.
To better understand, you mean that the commission means the seller pay commission to the buyer? For example, 3% commission? What is
The
that?
seller pays the listing firm commission, and then the listing firm shares their commission with whomever brings the buyer.
Yes, yes. Okay. Who need to share whom?
I'm sorry?
Who need to share this information to whom?
If you're the listing agent, if you're the listing firm, you're going to get a bonus or incentive. You have to share that with your seller client. If you're the buyer's agent and the sellers offer you a bonus, you have to share that with your buyers. Yep. Your principal, your client. Yep.
Okay.
Yep. We talked last night about improper compensation of an unlicensed person. Guys, remember, unlicensed people can only get hourly or salary. You cannot give them commission. You can't give them a referral fee. You can't give them a finder's fee. If they bring you business, all you can do is say thank you. You cannot pay them any kind of referral fee, finder's fee, anything like that. Remember our 3 ingredients for a license: transfer property for others for compensation. So if they're going to get paid for this activity, they have to have a license. And then remember Unit 21, we talked about RESPA. And one of the big things that RESPA now says is that we can't give or receive referral fees or kickbacks to or from settlement service providers. But also remember, RESPA and TRID are only involved if a lender's around. So if it's a cash buyer, can you accept a $25 Amazon gift card from a home inspector if it's a cash buyer? Sure, because RESPA's not around, right? So the real estate commission kind of picks up where RESPA leaves off. So if you have a cash buyer and you stand to make more money, I still have to disclose it. Okay. Let's talk a little bit more about the BIC. We talked last night a little bit about the BIC. Let's talk a little bit more about them. All firms have to have a designated broker in charge at each office location. So I think we're good with that. If your firm has 5 locations, then how many BICs do we need? We need 5 designated BICs, don't we? 1 under each roof. We talked about the criteria to become BIC eligible. I think we'll be reminded of that again in just a second. Anybody that's BIC eligible can become the designated broker in charge. Anybody that's BIC eligible is eligible to be the designated broker in charge. And a BIC cannot supervise more than 1 office at a time. A BIC can only supervise 1 office. One day, you guys may want to go out on your own, open your own firm, start your own company. You have choices if you want to do this. You can start your own firm. You have to get a firm license. You have to license your firm, and you can designate yourself. You can be the broker in charge of your own firm. If you just want to work for referral fees, for example, you may not need to set up a firm. You may not need to be the broker in charge. You could just be a sole proprietor. As a sole proprietor, you don't have to have a firm license. You don't have to have a designated broker in charge, as long as you don't plan to maintain a trust account, advertise your brokerage services in any way. I'm talking handing out a business card. Your business comes from 2 places if this is the case. You're either referring agent only, or you're doing business with those that should reasonably know that you have a license. Who are those that reasonably know you have a license? Mom, dad, significant other, BFF. You guys with me? The people that you talk to on a regular basis. So if you just plan on being a referring agent, you may want to consider not setting up a firm, just being a sole proprietor. And the 3rd criteria, it's sole. How many is sole? Sole is just 1. So as a sole proprietor, you can't have brokers affiliated with you. If you're going to do any of these 3 activities, hand out a business card, affiliate a broker, or have a trust account, then you have to create a firm, get a firm license, and set yourself up as the designated broker in charge. When I retire, this is the route I'm going. This will keep my license active. I can hand over my book of business, and say, any business you get from this book, I get X amount referral fee. I look forward to hearing from you. That's my plan. That's how I'm going to do it. Questions on this? Whether you need a BIC, sole proprietor? We talked about this last night, how you become BIC eligible. You have to have an active license on non-provisional broker status. You have to have experience, at least 2 years full-time, 4 years part-time within the 5 years. And you got to do that 12-hour BIC course. Once you do these 3 things and you're BIC eligible, once you're BIC eligible, then you can become the designated broker in charge. Again, it's a way down the road for you guys, at least 2 years away. So when you're ready to do this, refer to License Law and Commission Rule. I don't know what License Law and Commission Rule is going to look like in 2 years from now. So when you're ready to go this route, make sure you're doing whatever's current. Anybody thinking about opening their own firm one day? A couple of you? Good. Yeah, Yandis?
Yes, is another question. For delivery of instrument, is it a 3-day working, right? No Sunday or holiday?
Who, me?
No. For exam, for question, agent to deliver instrument within 3 days.
A day is a day.
Yeah,
Yep,
but
a day is a day. Sunday. The only
day.
Sunday and holiday that don't count is when you're counting for the closing disclosure from the lender. Lender delivery of the closing disclosure to the borrower.
2 in a holiday or? No.
We work every day, honey. Yep.
Okay.
So when we talk 3 days, a day is a day. The only time that Sundays and holidays don't count is when you're, like we said, the lender's law to deliver the closing disclosure 3 days to the buyer before settlement. Other than that, a day is a day. So if you want Sunday off, go ahead and deliver it Saturday, right?
Oh, okay.
Yep.
Thank you so much.
Yep. I put a house under contract once on Christmas Eve. I mean, we, you know. Did I not mention that on day one? Y'all like your weekends and evenings? Enjoy them now. Other questions? I hope we've pounded this in your head. Everybody good? I cannot draft legal documents for others. I cannot draft legally binding contracts. I cannot draft verbiage in an agency agreement. I cannot create an addendum. I can't draft. All I can do is fill in the blanks of the pre-printed forms. I cannot offer legal advice. When my buyer looks at me and says, should we be joint tenants or tenancy in common? I cannot whip out my pre-licensing book and proceed to explain it to them. I truly stand by this. So much of this class is teaching you guys just enough to be dangerous. But hopefully what you're hearing is we've got to stay in our lanes. I'm not an attorney. I'm not a lender. I'm not a homeowner's insurance agent. I'm not a home inspector. I'm not a general contractor. I'm just a real estate agent. So we need to know when to refer our consumers, clients, and customers to an attorney. Talking about our offers and sales contracts, our pre-printed forms have minimum terms. Again, these were drafted by members of the Bar Association. So attorneys draft the forms that we're allowed to use. Please remember, I don't only have to use NCAR's forms, North Carolina Association of Realtors forms. I'm free to use any contract I want. Commission rule says it has to follow rule.A1 or A0112. You don't need to know that number. But this rule provides 19 separate issues. And the rule says that if a licensed broker is using a contract that North Carolina Association of Realtors did not prepare, then I have to make sure that contract follows this rule or I can't use it. So there's 19 provisions. If you want to check it out, it's on pages 619 and 620 of your book. Don't need to know all this, just know, I think the problem topic is I only can use NCAR forms, and that's not true. I can use other forms as long as it follows this rule, follows this criteria. I think we mentioned it's really not uncommon for builders to have their own contracts, and it's okay for me to use those. Comments on that?
The book shows 20 provisions.
Well, there's 19. Yeah. So, okay.
20.
Okay. So let's look at page 619. So 20 is the other. So they specifically mention, they specifically mention 19. And then 20 is other provisions or disclosures required by state or rule. Others, the cover up, the catch-all. Reporting criminal convictions. We talked about that list last night briefly. This is a problem topic on your exam, so we're going to spend a minute on this slide. We're all good. Before you submit your application, you have to have a background check, right? They're going to look for errors of the past. Once you get licensed, you're not off the hook. Once you get your license, if you get convicted of a felony or a misdemeanor, please note the word convicted. Does that say charged of a felony or a misdemeanor? If you're charged of a felony or misdemeanor, you don't have to do anything. You don't have to do anything until you're convicted. Also, if you get yourself in trouble, if you have another professional license, not your driver's license, but if you have another professional license and you get yourself in trouble with that licensing board, we have got to report that to the Real Estate Commission within 60 days. Are they going to discipline you? I don't know. They're going to review it on a case by case. That's not what the rule says. The rule says we have to notify the commission. They will decide if they'll do anything, if they will, or if they won't. Our job is to report it. So once you've been convicted, not charged, once you've been convicted of a felony or misdemeanor, some of you might live near Virginia or South Carolina. I know a couple of you are all over the place. Anybody right near one of our borders? A couple of you. You may want to consider, once you get licensed in North Carolina, to get your license in South Carolina or Virginia. Because there's some of these weird towns in our country that the middle of the street is the state line, right? So your license says you can only show homes located, you can only be involved in the transaction if the property is located in the state of North Carolina. So if you're in one of those towns and you're showing a house and your buyer looks across the street and says, ooh, can we go see that one? If you're not licensed in that state across the street, then you can't show it to them. So if you're that close to the border, you may want to consider getting licensed in, getting dual licensed in the other state. I don't know other states' license law and commission rules. So you need to call the Virginia Real Estate Commission or the South Carolina Real Estate Commission and see what you need to do to get your license there. If, for example, you have a South Carolina real estate license, that's considered an occupational license, a professional license. So again, if you have a license, an active license with the South Carolina Real Estate Commission, you get yourself in trouble in South Carolina, you've got to report it to the North Carolina State Real Estate Commission. Anybody on here a CPA or CNA, or what are some other professional license? Any professional license. What questions do I have on this? This tends to be a problem topic. Everybody see the word convicted? 60 days to report it. Okay. In Unit 8, we talked about our residential property and owners association disclosure statement. The RPODs and the MOG, residential property owners owner association disclosure statement, and the mineral and oil and gas rights. These are the seller's responsibility to complete. I cannot complete these on behalf of the seller. They're seller disclosures. I can assist, I can provide the forms, I can tell them to complete them. I can't do it for them. If the seller fails to provide these forms, that could be a reason for the buyer to rescind their contract. There's rules in the contract that state that list the possible out for the buyer. And remember these forms, you guys, these are mandatory forms with optional disclosure, which means the seller has to complete them, but they have the right to say no representation. Mandatory form, optional disclosure. If the seller chooses to answer yes or no, they can't lie. They've got to answer honestly. Regardless of how the seller completes the form, we always have a duty to disclose material facts. So if the roof leaks and the seller says no representation, that's absolutely their right. Caveat emptor. That's absolutely the seller's right to say no representation. But when we find out the roof leaks, we have to disclose that. This is the form. These are the forms. The seller disclosures are what's under fire right now. Buyers feel that when they offer $50,000 due diligence, they have their home inspection, find out that the house isn't perfect, that the house has problems. They want to terminate, and they think that the seller should have to give their $50,000 back because the roof leaks and the seller said no representation. And the commission has recently come out. They published an article on February 1st. I put it in You'll Learn Test Pass for you guys, I think in the Unit 8 material, 9 or 10, somewhere in there. But the commission says it doesn't matter if due diligence is $1, if it's $10, or if it's $1,000. It does not matter. The seller doesn't have to disclose. We actually talked about this in our meeting, our sales meeting this morning. There's no such thing as a perfect house. There's no such thing. And buyers go, well, if I pay $50,000 and I'm going to get a perfect house, that doesn't change the fact that there's problems. Mandatory form, optional disclosure. We spent a good chunk of Unit 21 talking about our closing disclosures. Technically, it's our responsibility to make sure that the client gets a copy of the closing disclosure. How many days do I have to deliver the closing disclosure to them? 3 days. Deliver all instrument within 3 days. Technically, it's my responsibility. In practice, the attorney is giving it most of the time to the seller and the buyer at settlement. but I still have a duty to make sure that my client receives it. So that's one good reason for us to attend settlement with our clients, is to make sure they get copies of the closing forms. And remember, we have a duty to review the closing disclosure for accuracy, to make sure that the numbers that we can verify are correct. Make sure that the numbers in the closing disclosure match the sales contract. Make sure all invoices are accounted for. You now know how to do interim interest and excise tax, and you can prorate annual property taxes. Any questions?
I have a question, Julie.
Yes, yes.
So when you're talking about ensure delivery of closing disclosure to client, doesn't typically like the attorney send that directly to the,
Mhm. But it's still our duty to make sure that they get it.
okay,
That's a good reason for us to go to settlement.
okay, thank you.
Mhm. All right, long awaited. We're finally here. The trust account. We've been dancing all around this for about 8 weeks now. So now we're going to finally get to the trust account. Trust account can also be known as escrow account. We like using those interchangeably. There you go. The definition of a trust account. Trust account holds money belonging to others. The trust account is a safeguarding. Your money does not belong in the trust account. Firms that manage a trust account have two accounts. They have an operating account and a trust account. Trust account is a safeguarding place for other people's money. Why don't you guys tell me in a chat, private if you wish. We talked about, I'm thinking of specifically two monies. What are two monies that you would think would be held in a trust account? Two monies, and if you want to make it a private, that's fine. Two monies. Think about where this money is going. How about another hint? One involves sales and the other one involves lease. So I think for the most part, we got it. I'm seeing lots of due diligence coming through. Where does due diligence go? Who gets due diligence? The seller. The buyer pays that money directly to the seller. So what are we going to hold in the trust account? Earnest money and tenant security deposit. That's our safeguarding. Everybody good with that? The buyer writes a check to the seller. That money does not go in a trust account. So we go under contract, the buyer writes two checks, one to the seller and one to the escrow agent. You get a new tenant, the tenant's going to write money to for the security deposit. Not all firms have a trust account. If you're property management, you pretty much have to, right? Because you got to have somewhere for that security deposit to go. A lot of real estate firms are doing away with maintaining a trust account for the earnest money deposit. And what they're doing is letting the closing attorney handle that. There's a lot of liability involved in a trust account. And a lot of real estate firms are saying, too much. I'm going to let the attorney do it. If you join a firm that has a trust account, part of your new agent orientation will be discussion on how they want you how they want you to proceed, how they want you to request. Obviously, you're not going to have access to it, but how to request, how to turn in earnest money, that kind of thing. I think, let's see, I took a commission class last year, and I think they said only like 20% of sales firms in the state still has a trust account. So some of your bigger brands, some of your national brands may still have a trust account, but for the most part, most of us, we're not dealing with it. It's too much responsibility. The attorney has to have a trust account because that's how they disperse funds at settlement. That's how they pay everybody after settlement. So at some point, somebody woke up and said, why are we doing this when the attorney has to anyway? And we all jumped over that bandwagon. So again, I tell you, if you join a firm that has a trust account, they will tell you how they want you to proceed, how they want you to act. So earnest money and security deposits is typically what we see in the trust account. The trust account has 3 primary features that distinguish it from the rest of the account. It's separate. It's not an operating account. It's separate from the operating account. All you're doing is safeguarding other people's money. It's a custodial account, which means only a limited number of employees should have access to it. Obviously, the broker in charge, they may have their staff, maybe licensed or unlicensed, managing it. I managed a trust account for years as an unlicensed employee. About 3 of us had a key to my office, my BIC, myself, and then another peer of mine, in case I fell off the face of the earth. Once you got in my office, you needed another key to access the cabinet with the trust account. And only 2 of us had copies of those keys. It was highly regulated, locked up. Yeah, Danielle.
So I know we're going over the features. I was wondering, I was reading about the interest-bearing trust accounts, and I don't know if you're getting there, but I'm just trying to understand the purpose of having an interest-bearing account if it's bearing interest, and it makes no sense to me.
Well, if you make money on it, then you just transfer it from your trust account to your operating account. Yep, and we are kind of getting there, but yeah, if you're making money off of it, then each month when your interest comes in, you just transfer it to your operating account. Yep.
And that is counted as like an expense?
It'd be money coming in to the firm because you're earning that interest. So income. With a custodial account, bottom line, you guys, nobody that has money in the account should have access to it. So your buyers, your sellers, your tenants, they shouldn't have access to the account. And then the account has to be available on demand. Let's say it's a bad day and every single one of your buyers terminate. You need to be able to refund all of that earnest money. You can't say something like, oh, wait until I get paid on Friday and I'll pay the rest of you. It's available on demand. So it's a demand deposit account. Like we said, it needs to be in a bank, FDIC. Not all banks are FDIC. I learned when I was setting up my trust account when I got my tenant. I found that out. So like, for example, credit unions, I found out, are not FDIC. So it's got to be federally insured depository institution. The bank has to lawfully be doing business in North Carolina. The bank doesn't have to be located in North Carolina, but it has to lawfully be doing business in North Carolina. And if the real estate commission walks in the front door and says, show us your records, show us your trust account, you need to make those records immediately available for the real estate commission for inspection. You can't say, oh, give me a minute, let me balance it real quick. If they walk in the door and want to see your records, you need to have those account records available for inspection by the real estate commission. Yeah, Clara?
Julie, when you were referencing the scenario in which there was, only 3 of you had a key to your office and then only 2 of you had a key, what did you have a key to? A safe? Was money?
That was just a file cabinet.
Oh, it was a file cabinet. Okay, because the money was kept in a bank account.
Yeah. Oh, yeah. But the records were in my office in the file cabinet. Yep.
Guys, it's records. Yep. Okay, thank you.
Yeah, no, the money was in the bank. I got to go to the bank every day, which means I got 15 extra minutes for lunch, even though the bank was only like 4 minutes away. See what I did there? I guess my point, and I apologize. I guess my point was that the records were safeguarded. Not everybody had access to the records. The records were very safeguarded. Okay. All right, let's pause here. I got more to talk about the trust account. I know you guys got questions, so just bear with me. Let's pause here before we go to break. Please don't go anywhere. Please, please don't go anywhere. Remember, guys, tomorrow you are with Ann. So let's see. Here is Ann's Zoom link. If for some reason it's not coming through in the chat, if for some reason you're not getting it, please email me by like 3 p.m. tomorrow, because I'm not available after that. So if you're trying to get on the call at 5:30 tomorrow night and I'm not available, I can't help you.
So you're not gonna be teaching tomorrow?
That's correct. You're going to be with Ann Rashid tomorrow.
Oh, good.
So here's Ann's Zoom link, her meeting ID and her password. Does everybody have, please everybody give me a thumbs up that you got this. It's important to me that you guys can access this tomorrow. If for some reason you don't have it, please email me by like 3 o'clock tomorrow so I can get it to you. Okay. Questions on tomorrow night. I'm sorry, I thought I discussed this last night. I'm not able to be with you guys tomorrow night, but I got you in good hands. Ann's prepared to do a full review with you guys, kind of help you pull together everything. If you're thinking about not coming tomorrow, you need to make sure you're within your hours, because tomorrow is a class. It will count against your time if you're not here. Ann is sending me her attendance records Friday morning. So if you think, woohoo, I get a day off, you better check with me first. Make sure you can afford to miss 3 hours. Wouldn't that be horrible? Questions on tomorrow night? Okay. And then don't forget your Cram course with Jane is on Saturday. Saturday 9 to 1 is the Cram course. Here is Jane's link. Saturday 9 to 1. Jane will cover primarily the state section and the math. So she'll do a little bit review, whatever she can do in 4 hours. It's totally optional. You can come if you want to. You don't have to come. You can come for 30 minutes, 2 hours, 4 hours. You cannot use Cram course to make up for lost hours. You cannot use this to make up time because it's optional. It's not required. It's not mandatory. Jane will record. So as soon as I get the recording link from Jane, I'll put it in our YouTube channel so you guys will have access to it. Once again, I'm not available Saturday morning. I'm teaching another class. So make sure you have this. If for some reason you didn't get this link, please reach out to me by Friday night so I can send it to you, because I'm not available to help you Saturday morning get in. How many of you think you might be coming to Jane's? I'm just curious. Quite a few of you? Good, good. You know, what I like about the Cram course, Jane's not going to say anything new, but I like that you guys have an opportunity to hear it a different way. Sometimes hearing the same information a different way will help things click. And that's why we offer the Cram course by a different instructor. You've been listening to me babble on for the last 8 weeks, right? Isn't it going to be nice to hear somebody else babble on about the same stuff? So she can kind of have maybe put it in a different perspective to help you guys get a better understanding of it. So tomorrow night you're with Ann. Saturday you're with Jane. If I have any questions on that, please reach out to me. Call me, text me, email me. Please reach out to me. Fair enough? Everybody good? Questions about either? Okay, let's take our break. When we come back, we're going to talk more about the trust account.
Julie, I have a really quick question.
Yes, ma'am.
Yeah, and this is probably a silly question.
Not at all.
Are the chat part of this Zoom link, will they be available to us even when the session ends?
I don't know if you, I think you have to have that turned on in your end.
Okay, so really I just need to copy and paste
Yes.
the links.
Yes.
Okay.
Yes, put them in, maybe you can throw them in like an email or something, so you can email yourself and have them. And that's what I'm saying. If for some reason you can't get it, just email me and I'll reply and say, here you go.
Okay, thank you.
Okay, sure. Thank you.
I have another quick question for you. Totally. Oh, never mind. I went to come back.
Nope. I'm here. Hi.
Okay. So I was going through the final exam, the one that was graded, I believe it's in Learn Test Pass, the very last test. It was dated for like 5/20 final exam. And then you have 100% exam at the beginning of that same section, right? Those two separate exams. The way those are tested are kind of, as far as depth of knowledge, are kind of different. So I kind of want to see, does the depth of knowledge more so relate to that last exam, the 5/20, or the of the 100% exam? Like, which one do I need to be studying more for?
I'm not
That
gonna
makes
lie, I
sense?
don't remember exactly what was in the 521, but I think they're both good practice. So as far as the depth, I think you can kind of use them for what kind of understanding I have.
Yeah.
The interactive one, Learn Test Pass, all the interactive quizzes are written by the creators of Learn Test Pass. These other flat PDFs are just exams that we grabbed from other places over the years, right? So
Gotcha. Okay.
a lot of students say that the questions in Learn Test Pass are similar to what you see on the state exam. I'm a big fan with the more practice, the better, because if you can get through those, then you're going to be prepared for that state exam. That's
Exactly.
my
And that's
theory.
exactly how I felt, because the
Perfect.
Learn Test Pass questions are a lot more in depth. So
And
yeah.
if you can get those, then you should be able to have that understanding to get through the test. Absolutely.
Okay. Thank you.
Sure.
Nope, you have 2 more minutes. I said
All right. Got a couple questions I'm getting ready to address, so just hang on 1 second. Let me take attendance once I have cameras back on. Those links that I just gave you guys in the chat. Let's see, are we back? Those links, we're taking attendance now. Those links that I just gave you guys in the chat, you can copy and paste those links into, like, for example, somebody suggested Notepad. You can do it in an email to yourself. So you'll have those links to click on tomorrow night and Saturday morning. So what do you do with those? I don't know if you guys get the chat log from Zoom. I think that has to be turned on your end. I don't know that much about that. So the links that I just gave you for Ann's Zoom and Jane's Zoom, what I'd like you to do is copy and paste those and put them in an email and email them to yourself. So you'll have them tomorrow night and Saturday. And a couple of you just sent me an email asking for me to send them to you, and I'm happy to do that. I'll get to you after class. So if you would need me to send them to you, just let me know. Questions on how to get those links? Ann's is tomorrow. Jane's is Saturday. Don't click on Julie's link tomorrow. You're not going to go anywhere. Don't click on Julie's link on Saturday. You come to post licensing. That's not going to help you. Questions on that? Everybody got the links? Everybody good? Again, just email me. Just email me. Please send me an email and I'll respond. Please just send me an email. Julie, the real estate instructor @gmail.com. Other questions about that? And does not record. So tomorrow night will not be recorded. Saturday's Cram Course with Jane will be recorded. So I'll be able to put Saturday's Cram Course in our YouTube channel once Jane sends it to me. Other questions about tomorrow or Saturday?
Sorry, tomorrow is the same time?
Yes, 5:30 to 8:30. Yep.
Okay.
Tomorrow counts as class time. So everybody understand that. If you miss tomorrow, you're down 3 hours. Thank you guys for telling me you're back for break. Okay, so let's see, trust account. Still got a few more things to say about this. I know you guys got questions, so let's see we can answer some of those questions. Demand deposit, custodial means nobody else's money is in it. It's limited who has access to the records. The commission requires the actual words, trust account or escrow account, to be on all the records, signature cards, bank statements, deposit tickets, checks. The reason for this, let's imagine that you're an independent broker. You're not affiliated with a firm. You have your own firm. You work for you. And the independent broker passes away. They don't want this money locked up in their estate because it's not the broker's money. It's money that belongs to others. So by identifying everywhere that this is a trust account or an escrow account, it can't be frozen in the event that an estate or some kind of pending investigation. And with each money, it has to have accurate records. You got to say who the parties are. Buyer, seller, lessor, or lessee, what's the property address, what's the date of deposit, date of withdrawal. Getting ready to tell you how old school I am. I don't know how they're doing it today, but back in the day when I managed the trust account, had these little green ledger cards. If you ever worked in an accounting department, you know what I speak of. Had these little green ledger cards. We didn't have e-files back then. So I'd actually take the green ledger card and keep it in my records. And when we closed it out, that green ledger card became part of the transaction file. Anytime money came in or out, we indicated, we noted that money was going in or out of that trust account. If you're working for a firm that maybe does for sale and for lease, you only need one trust account. You can have earnest money and security deposits in the same account. You can choose to have separate accounts, but you only have to have one trust account. The exception to this rule is if you're a property management company and you manage more than one HOA. Each HOA needs their own trust account. So if you manage 5 HOAs, you need 5 trust accounts, one for each HOA. That's the only exception. Otherwise, you don't have to get multiple trust accounts. The biggest mistreatment of the trust account is commingling. Commingling is putting your money into the trust account. Remember, the trust account has other people's money in it. Your money does not belong. No commingling allowed. This is probably one of the biggest violations in the disciplinary action in the e-bulletin is commingling a trust account. Your money goes in your operating account. The question came up a few minutes ago, what if you collect interest? Well, once a month, you transfer that interest from your trust account to your operating account. Once you earn that interest. The exception to the no commingling rule. If your bank charges a monthly fee, and they're going to do an automatic draft from the account, then you can have up to $100 at a time of your money in the trust account. So when that automatic draft happens each month, it's not being drafted from somebody else's money. So you can have up to $100. Once that supply deplenishes down, then you put up to another $100 in it. And that way, when they do the automatic bank draft of $12 a month, that $12 comes out of your money and not money that belongs to others. Questions on commingling? The broker in charge is the one that's ultimately responsible for the trust account. They can let an employee manage it, licensed or unlicensed. But if the real estate commission shows up and says, hey, we want to look at your trust account, they're going to the BIC, because they're the ones that are ultimately responsible for it. As we mentioned, the access should be limited. It should be controlled. Who can access those records? Records need to be current and accurate. We don't have a definite definition of current, but I'm kind of under the philosophy you get the bank statement once a month. So that's when you sit down and make sure everything balances out. Keep it current, make sure it balances with the bank statement. For earnest money, when it's time to go to closing, they have to release the earnest money deposit to the closing attorney. We've got to get it to the attorney so it can be counted towards settlement, credited to the buyer at settlement. It can't be dispersed no more than 10 days prior to settlement. Again, if you join a firm that has a trust account, they'll tell you how they want you to handle this. Who in the office do you go to get the earnest, request the earnest money check to take to closing, that kind of thing. If the property doesn't close, if it's terminated, we're good with this? Why don't you guys tell me in a chat, private chat. If the transaction is terminated while we are still in due diligence, who gets the earnest money? You can tell me B or S. There, I just gave you a hint. B or S, if we're still in due diligence, who gets the earnest money? Still in due diligence. If we're still in due diligence and we terminate, the buyer gets the earnest money back, right? The seller will keep the due diligence, but the buyer will get their earnest money back. Who gets it if we terminate after due diligence? Who gets the earnest money if we terminate after due diligence? So if we terminate after due diligence, the seller will get it. Now the buyer's in breach. The seller's remedy is keep the due diligence and they get the earnest money. Here's the deal, you guys. If we terminate, the parties have to agree to release the earnest money. Even though the contract is very clear about what happens to the earnest money if we terminate within due diligence or outside of due diligence. Now I can't. So the parties have to agree to release the earnest money. And if they don't agree to release the earnest money, then it's a disputed earnest money. The funds are in dispute. The bearer of the trust account can't release the funds until the parties agree. So they have to sign a written release of the funds. Even if the earnest money is held by an escrow agent, an attorney that can interpret the contract, they have got to hang on to the earnest money until the dispute is resolved. If after a certain period of time, I honestly don't know what that certain period of time is, but after a certain period of time, if they still haven't agreed to release the earnest money, then the escrow account, the bearer of the escrow account, can release the funds to the clerk of court's office, and the two can go hash it out in small claims courts. So again, even though the contract is very clear, this is what happens if you terminate within due diligence. This is what happens if you terminate outside of due diligence. The parties have to agree. They have to sign a written release of the earnest money. And if that money's in dispute, whomever's holding the earnest money can't release it without written permission of the parties. X amount of time, they turn it over to the clerk of courts, and the two go duke it out in small claims courts. Questions about that? Disputed earnest money. Disputed earnest money rules don't apply to tenant security deposit. This is only about earnest money.
So Julie, it's not an automatic.
Nope, they have to release it. They have to sign to release it. Yep. If it's in dispute, if somebody's digging their heels in and not signing, the escrow agent can't say, well, the contract says the buyer should get it, so I'm just going to check the buyer. No, they have to release it. Other questions about that? If the earnest money is in dispute?
Okay, Julie, I'm sorry. Well, what would be the point of the contract if the contract
I know, right?
spells it out?
I'm with you. I'm with you. However, the parties have to agree to release it. Contract's what they take to the judge, right? When they go to the clerk of courts to duke it out, the contract's what they take the judge, and the judge is going to look at it and says, well, it says right here who should get the earnest money. So they're going to release it to the appropriate party. I guess the thinking here is that the attorney or the real estate firm isn't the judge. They can't make the parties perform. Other questions on that? Once you get trust monies, we have 3 banking days of receipt to deposit them. You get an earnest money deposit, it needs to be deposited within 3 banking days. You get a security deposit, it needs to be deposited within 3 banking days. The exception to this rule is cash. If you receive cash, get it in the bank. Let's have a conversation. Let me clarify. Let's have a conversation about this. This says 3 banking days within receipt, which is accurate. So let's say we receive the earnest money today, which is what, the 23rd. So you got, today's Wednesday, Thursday, Friday. So we'd have to have it in by Monday, 3 banking days, right? Do I have everybody? There may be a situation. So let me add to this: receipt or contract formation. There may be a situation when you're negotiating an offer on behalf of a buyer, and they may hand you their earnest money deposit check and say, hey, will you hang on to this for me while we're negotiating the offer? In that situation, the buyer doesn't owe any money until the contract's been formed. So if you're still negotiating the offer and you're not under contract yet, and the buyer says, hey, will you hang on to this for me? You're not going to deposit it 3 days of receipt. You're going to deposit it within 3 days of contract formation. We're not going to put it in the bank until I have a contract. So either 3 days of receipt or contract formation. So you're handed it today, you're negotiating the offer. Let's say you finally get it worked out and you go under contract on Friday. Now you have 3 days on Friday when the contract was formed to deposit the earnest money. And again, the exception's cash. Because if the offer never becomes a contract, I can write a check for cash. I don't have to wait for cash to clear the bank. So 3 days of receipt or contract formation. You guys, as soon to be provisional brokers, you guys cannot walk around with somebody else's money. Provisional brokers cannot walk around with somebody else's money. So again, if your buyer says, while we're negotiating this offer, here's my earnest money check, will you hang on to it for me? As a provisional broker, you need to immediately get it to your broker in charge. You can't walk around with somebody else's money. So you're in the throes of negotiation, your buyer hands you the check, get it to your BIC, they will safeguard. If it goes under contract, get it in the escrow account within 3 days. If it doesn't, you get the check back to your buyer or destroy it of it according to their instructions. The rule of thinking here is that provisional brokers cannot walk around with somebody else's money. Full brokers should not walk around with somebody else's money. If anybody else's money is in your possession, it's your responsibility, regardless. So my suggestion to you is to get it to where it needs to go. Trust account rules also address option money or due diligence fee. While the due diligence is paid from the buyer to the seller, we usually do assist in delivering that. So when we go under contract, the buyer will give their agent 2 checks, due diligence and earnest money. Agent will deliver it to the escrow agent for the earnest money. The due diligence, the buyer's agent will deliver it to the listing agent. Then the listing agent delivers it to the seller. So even though due diligence isn't trust account, we still have rules involved in getting it from buyer to seller. We got to get it from the buyer to the seller, no more than 3 days. The contract says the due diligence is due by the effective date. So the sooner, the better. If you're the buyer's agent, you go under contract and you meet your buyer, Chick-fil-A parking lot on a Sunday afternoon to get their earnest money and their due diligence checks. And those checks are in your hand and you're going to deliver them Monday morning. You're going to get them to where they need to go Monday morning. If those checks are in your hand and your buyer calls you on Sunday night and says, don't deliver them, we have to follow our buyer's instructions. If they're in your hand and they say don't deliver them, it is their money. I'm simply acting as the vehicle to deliver it. And if they instruct me not to deliver it Monday morning, I'm going to tell them you could be in breach, the seller could terminate, da, 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 da. But ultimately it is up to them. So if we're advised, if we're told not to deliver it and it's still in your hand, obviously once you've delivered it, you can't do anything. But if it's still in your hand and they call you and say, don't you deliver that money, we have to follow their instructions because it's their money. What questions do I have on that? We follow their instructions about handling their money. Like we said, you guys, all licensees are responsible for safeguarding trust money, due diligence fee, whatever, regardless of whether the firm has a trust account or not. If somebody else's money is in your possession, it is your responsibility. So once again, I suggest you get it to where it needs to go. Get it out of your hands. There's license law and commission rule on the trust account. The real estate commission says as long as you know the information we just talked about, 725 to 727, that's the information you'll need for your exam. So you don't need to worry about the law and the rule. Just know the information for 25 and 27, 725 and 727. Any questions on the trust account?
So just thinking this through, Julie, like you're talking about these checks. Let's say your buyer bounces the check. Their breach of contract because technically they haven't paid, right?
No. And that happens, by the way. So if the check bounces, I think the contract says that the funds aren't honored, but let's call it a spade here, right? If the check bounces, the seller provides written notice. They have 1 day to provide written notice to the buyer to request new funds, readily available funds, no personal check. Your check already bounced. I now want readily available funds. Seller provides written notice. Buyer has 1 banking day to deliver readily available funds. And if they fail to do that, then the seller may terminate. They don't have to. But in order for them to have that option, they have to provide written notice and give the 1 banking day. And sometimes those checks bounce. Sometimes those checks bounce. And the seller just can't say, whoop, it bounced, I'm out. Written notice, 1 banking day, and then they may terminate if they choose. I'll tell you guys a funny story in just a second. Yeah, Claire.
What format should that written notice be in? Can it be an email?
I got a form. I got a form.
But okay, but it can be sent via email?
Sure, but we got a form.
Okay.
The real estate commission or the NCAR. Question comes in, where's a cash buyer bring their money to the attorney's office? And they can't show up with a big bag of cash, right? They're going to have to show up with a cashier's check or wire transfer. So back in the day when I was doing the trust account, I had an agent that had a client that was buying herself a home, one for her mom and one for her sister. It was in a new homes community and she wanted us to be neighbors. So she was buying 3 homes. We had 3 contracts, 3 earnest money checks, 3. I don't think due diligence existed back then. Due diligence is fairly new to this state. So I think it was just 3 earnest money checks. All 3 of those earnest money checks bounced. I got the mail that day and I got 3 statements from the bank saying this funds were not honored, funds were not honored. Y'all want to know what happened? She thought she had money coming from overseas somewhere. So she forged a letter from her bank, grabbed the logo online and everything, copy and paste. She was convinced that this money was coming from overseas. She had terminated all 3 contracts because guess what? That money never showed up. All 3 of those earnest money checks back. Isn't that horrible? I hate to hear stories like that and people get taken. I called the agent. I was like, I don't know what's going on, but all 3 of them. Other questions on the trust account? Okay. The last piece, I'm sorry, do I have a question? The last piece in this section is just kind of a quick refresher on our BPOs and CMAs. Talked about these in Unit 17. Provisional brokers cannot perform a BPO or CMA for a fee. You can do a BPO or CMA, but you cannot do one for a fee. Nobody can determine value unless you're an appraiser. So BPOs and CMAs are not meant to determine value or opinion of value. They determine estimate probable selling price or probable lease price. When y'all are sitting at that listing appointment, don't look at your seller and say, I think your home is worth X amount. You look at the seller and you say, I think your probable sales price is. If you're doing a BPO or CMA for a fee, you have to be in compliance with Article 6 of license law. Again, you don't need to know Article 6, but just know it's a license law. There's rules on ways you have to present the BPO or CMA when you're doing it for a fee. And all of them have to be in writing. All BPOs and CMAs have to be in writing. So that's our license law and commission rule comments. I think a good chunk of your state exam is coming from the comments starting on page 707. In addition to the comments, we need to go back through Appendix A and grab a couple other license law and commission rule. So we're going to kind of be jumping around a little bit, but I got page numbers for you. So let's go to page 611. (611) is a commission rule about proof of license. Once you get your license, you're going to get an actual 8.5 by 11 license in the mail. It'll look a little something like this. Y'all get you a nice frame for it. You guys worked hard for this. Hobby Lobby puts these on sale every once in a while. So you'll get one of these when you get your license. Hang it proudly, as I do. In addition to your 8.5 by 11, each year that you renew, you'll get a pocket card. Now we'll talk about the renewal process in just a minute. So each year that you renew, you'll get a pocket card. They do have a digital pocket card now. So you can either cut out a little piece of paper and stick it in your wallet, or you can get a digital copy on your phone. But that pocket card has to be on you whenever you're engaging in brokerage activities. So when you're meeting with buyers or sellers, when you're doing an open house, a lot of times your pocket card is entry into CE, continuing education. We'll talk about CE in just a second. All firms also have a real estate license. The firms have to display their license in the office. The firms have to display their license in the office. Questions on proof of licensure? Just to point out, bottom of 611, broker name and address. How many days? How many days do you have to change your name or address with the real estate commission? 10 days. That's where we get that rule. Over on page 612, 613. Goodness, there's the rule on agency agreements and disclosures. Agency disclosures. 614 is the rule on advertising. 615 is delivery of instruments. Retention of records. We talked about this stuff, but just to point it out to you. 616 brokerage fees. 617 broker in charge. 619 tells us we can't draft. 619, there's our offer and sales contracts with our 20 provisions that have to be required if we're using a contract other than those provided by the North Carolina Association of Realtors. 620 is the rule on reporting criminal convictions and disciplinary action. 621 to residential property disclosure. We looked at in Unit 8. Let's fast forward to page 627. There's a commission rule about disclosure of offers prohibited. I cannot disclose the terms of an offer without the express authority of the offeror. Who's the offeror? And please don't say buyer or seller. Who is the offeror? Yep. The offeror is the giver of the offer, the one making the offer. And they're making the offer to who? The offeree. Offeror is the giver. Offeree is the receivee. So this is big right now in this multiple offer world that we're living in. Huge right now. You're a listing agent. You have 25 offers in your hand. Buyer number 26 calls, or buyer's agent number 26 calls and says, hey, what's everybody else offering? How much is everybody else offering? How much due diligence are they offering? Can you disclose the terms of the 25 offers you have in your hand? Not unless you get permission of those offerors. And do you think any offeror in their right mind is going to give you permission to disclose the terms of their offer? Probably not, because then they could beat it, right? As the listing agents, you need to be very careful that you don't discuss the terms of the offeror. What if you're a buyer's agent, you're working with two buyers that are interested in the same property? Can you pit your buyers against each other? Can you say, I know what they're offering in due diligence. I know what they're offering in earnest money. Guys, we do comps. This is why we do good comps. So everybody can make the decision. Remember, every buyer has different risk tolerance. Some are willing to offer more due diligence than others. We have the conversation with each buyers. How much are you willing to offer? How much due diligence are you willing to offer? We can't say, well, I know for a fact there's a buyer that's getting ready to make an offer with $50,000 due diligence. Everybody with me? You cannot, unless you have permission. And again, if you were given an offer, would you give anybody permission? I sure wouldn't. Questions on this? Yeah.
Julie? Hello?
Hi.
Okay, so what if you have multiple buyers and you have a cutoff time? And at that cutoff time, you have a buyer that's willing to pay X amount of dollars at the moment of that cutoff time. Is that acceptable?
I'm sorry, I'm not following. I'm not understanding.
Okay, so if you have a buyer and
Mhm.
they're saying, I'm willing to pay X amount of money at the cutoff time, go over what all the other offers are coming in at.
It sounds to me like you're talking about an escalation clause. So the buyer's willing to their offer is willing to beat whatever else is on the table. There's some, in escalation clauses are beyond pre-licensing. We'll talk about these in post actually. But there's some concerns about escalation clauses just because you don't know how much your buyer could be paying because you don't know what the highest offer is, right? And then the other concern is, how does your buyer know that they're beating the highest offer if we can't disclose? Technically, we can't disclose it until we're under contract.
Yeah,
So-
but I'm saying, like, say if that cutoff time is at 7 o'clock that evening, they're not accepting any more buyers
Mhm.
offers. But you have already indicated that you're willing to pay X amount over the highest price that you have already received.
So that's called an escalation clause.
Okay, my son done that down in Atlanta,
Yep.
and that's
Yep.
why I'm asking you this.
And yep. And like I said, that they're pretty much submitting an offer saying, here's my offer, but I'll beat the highest thing you got. And like I just said, the problem with that is I still can't show you the highest thing I got. You got to trust me, right? Now, after we go under contract, it's no longer an offer. So now I can show you that you beat the highest thing that I got. But goodness, what kind of risk for the buyers? So the commission's starting to say, y'all be really careful with these, and some buyers are doing that because they're like really desperate. They're saying, I don't care. I just want to be picked. But again, you got to know that I'm not lying to you, right? Because I still can't show you my other offers. I still can't disclose those other offers. So we go under contract and then maybe I can disclose, but I think and again, we're getting out of the realm of pre a little bit, right? And we'll talk about it in post actually, but I think we can all understand the concern of the buyers in this case, in this scenario. But buyers are incredibly desperate right now, and they're doing crazy things like escalation clauses to try to get their offer accepted. But how risky. And again, all buyers have different risk levels, right? I can't determine what your risk level is. All I can tell you is what your risk is in doing something like that. And one of the risks is you have to assume that the listing agent's telling you the truth. Okay. I agree with that. Somebody said may not be an effective strategy because not all sellers may not be motivated by money. You're right. There's other terms in the offer. There's other terms in the offer than price that the seller needs to take into consideration. And I would agree with that. I had a teammate, I guess it was last year. He was working with a buyer. It was a multiple offer situation. He didn't feel like they had a strong offer, but he was the buyer's agent. So he presented the offer that his buyers were comfortable with. Their offer got accepted. He was shocked. Listing agent called him and said, congratulations. She said, by the way, I just want to let you know, you were not the most expensive offer. You did not have the best offer. And he said, then why did you accept mine? There was a comment in agent only that the sellers were requesting a form, and I don't know what form, it's not important, but the sellers were requesting a form. When you submit the offer, submit this form. And my teammate was the only one that followed instructions. My teammate was the only one that submitted the form. And the seller said, we want to work with that one because he followed instructions. He did what we asked. He wasn't the best offer. He wasn't the most expensive offer. He wasn't the highest offer, but he still got his buyers in because he clicked and followed instructions. So you're absolutely right. It's not all about money. Okay. So let's skip ahead to page 638 and talk about your license renewal, license category, license status, license renewal. Our licenses expire every year at midnight on June 30th, unless you renew them. Our licenses are only good for 1 year. The Real Estate Commission works on a physical timeline. They don't work on a calendar year. So the Real Estate Commission's year is July 1st to June 30th. They work on a physical year. We have to renew our license every year. And there's a couple steps to this process. How you renew your license is to send in the renewal fee during the renewal period. The renewal period every single year is May 15th to June 30th. So each year, somewhere between May 15th and June 30th, you renew your license. For the past, I cannot remember how many years, the renewal fee has been $45. So you send $45 in. I'm so proud of the Real Estate Commission. It's only been within the last 3 or 4 years that they now only accept online payment. You can't send them a check anymore. Look at them go. So you renew online every year from May 15th to June 30th. Failure to renew your license between May 15th and June 30th means at the stroke of midnight on July 1st, your license is expired. When you renew your license every year, your license, when you renew it, is current. We're going to talk more about a current license. When you guys see the word current, I want you to see the word currency. When you see the word current, see the word currency. How do you keep your license current? You show them the money. You pay the renewal fee and you show the Real Estate Commission your money. Pay your $45 or whatever it is, subject to change, of course. Failure to pay the fee means your license is expired. So there's 2 categories, either current or expired. Questions so far? And by the way, you will know that it's the renewal period. They'll email you, they'll send you a postcard in the mail, your BIC will be on you. Just pay the $45. Yes. You have to renew your, no matter when you get your license, you have to renew your license every year between May 15th and June 30th. In order to have an active license is the only license status in which you can get paid any type of compensation. Active license is the only status in which you can promote or advertise your services in any way. If my license is not active, I cannot hand out a business card. So active, paid, or advertise your services. Question came in. This is everybody. Brokers, PBs, BICs, everybody. Limited service, limited commercial residents. Everybody renews every year, May 15th to June 30th. To keep an active license, you renew each year and you do your continuing education. We're going to talk about CE in just a minute. So every year that you want an active license, you send in the renewal fee for it to be current, and you do your CE, which I will talk about in just a second. So a current license can have one of 2 statuses. A current license can be active. As a provisional broker, take this a step further. What do you have to do as a provisional broker to be active? and you tell me in 3 letters, what do you have to do as a provisional broker to have an active license? As a provisional broker, you have to have a BIC. You have to affiliate with a firm. Now, we're going to talk about you guys in just a second about your license. So to keep your license active, you pay the fee and you do your CE. Doesn't that kind of rhyme? Just pay the fee, do your CE. That'll keep you active once you drop your provisional status. A current license can also be inactive. Why is it current? Why is it current? Because you paid the fee. Why are you inactive? You didn't do CE. You're a PB without a BIC. You didn't complete your post licensing in time or by choice. You could ride for the rest of your life on an inactive license. As long as you keep sending in that fee every year, you can ride for the rest of your life on an inactive license. You never have to activate it. Why would you do that? We'll talk about that in just a second. So a current license means you paid the fee. You paid the fee to the real estate commission. Current licenses can be active or inactive. To be active, you pay the fee and do CE. Active or inactive, you're either PB without a BIC, CE is not complete, post not complete, or by choice. Failure to pay the fee means your license on July 1st is expired. I don't care if you've done CE or not. That make no difference. You don't send that fee in, the stroke of midnight on July 1st, your license is expired. Questions so far? I'm not done talking about this, but. Okay. So let's take a break. Yeah, Claire?
What if you're in the middle of a real estate transaction when your
Doesn't matter.
license expires? Do you have to
Doesn't matter.
cease and desist everything then?
Yep. You can only practice with an active license. I'll follow up to that in just 1 second. So let's take a break. Remind me if I forget, but I'll take a break. I have a accept, of course. So I'll talk about that in just a second. So let's take 10. We come back, we'll keep talking about this. Take attendance. So the question came in right before break. What if your license goes inactive or current and you're in the middle of a deal? The real estate commission says that if you brokerage the majority of the deal, so in other words, you're like days away from closing. If you brokerage the majority of the deal and you stop brokerage activities when your license goes expired or inactive, if the firm policy allows it, you may still could get paid. But the firm's policy has to allow it, and you do have to stop and desist when your license goes inactive or expired. So the commission may allow you to get paid on an inactive or an expired license, but it's up to the firm. So how do you keep your license active? There's two pieces for an active license. Two pieces for an active license. And they rhyme, actually. Yeah. You pay the fee and you do your CE. And again, I'm going to talk about CE in just a second. Even if you pay the fee, as soon as you pay the fee, your license is current. So you pay the fee, your license is current. Now the question is this current license active or is it inactive? Is this current license active or inactive? A current license has everything to do with money. It has nothing to do with education. A current license has everything to do with whether or not you've paid the fee. It has nothing to do with your CE or your post licensing. What questions do I have on problem topics, you guys? So you guys, provisional brokers, you get your new license. Congratulations. Go out and celebrate. You deserve it because you worked hard for that. Trust me, it's recognized when you get your license how much, because we had to do it too, so we know. You get your license, go out and celebrate, but guess what? It's inactive. So as an inactive provisional broker, what can you do? Absolutely nothing. You can't advertise your services. You can't promote your businesses. You can't receive any kind of referral fees or commissions or bonuses. As a provisional broker, to have an active license, you have to affiliate with a firm. Remember I said earlier you could ride for the rest of your life on an inactive license. What if you're inactive for years and years and years, or just a year, and you wake up one day and you decide you want to activate your inactive license? 10 years inactive. How do you stay inactive for 10 years? You send them money for 10 years. Every year you renew by sending money. Do I have everybody? You keep it current. You send the fee. Let's say you're inactive for 10 years and you wake up and you say, oh, I want to activate my license. You're already current. You've been paying the fee this whole time. How much, if any, education you would have to do to reinstate an inactive license depends on how far behind you are on your CE deficiency. You can take CE on an inactive license. You could choose to take CE to stay current. If you do that, if you want to activate, all you have to do is call the commission and say, hey, I want to activate my license. If you're delinquent on your CE, then they're going to make you do CE to get caught up. So if you're inactive with no CE deficiency, all you got to do is submit the form. You're already current, which means they've received a renewal fee. Is it inactive? You chose to do CE, all you got to do is submit a form. If you're inactive for less than 2 years and you have a CE deficiency, They're going to make you do this year's update. I'm going to talk about CE in just a minute. They're going to make you do this year's update, and they're going to make you do a couple extra electives to get caught up. So if you have a CE deficiency of less than 2 years, you're current, which means you've been paying the fee for 10 years, but they're going to make you get caught up, or less than 2 years, excuse me. They're going to make you get caught up on CE. If you're inactive for more than 2 years with a CE deficiency, in addition to doing this year's CE, you got to retake 2 post-licensing classes. The thinking is if you've been more than 2 years without continuing education, you're rusty. The rules and the laws change so much, so fast. If you're inactive and no CE, they're going to make you come back and do 2 out of the 3 post-licensing. Remember, if you're inactive, you're not marketing, you're not advertising, you're not promoting your services, you're not receiving a commission or referral fee. And I hear you guys asking yourself, if I'm not going to be in real estate, why in the world would I keep sending them $45 every year? Guys, I'm telling you, and I'm getting ready to tell you why. It's so much better to ride on an inactive license than it is to let your license expire. Why does your license expire? Because you didn't show them the money. You didn't pay that fee by July 1st during the renewal period. So you choose to be inactive. Maybe you have another career opportunity. Maybe you're going to stop and start a family. Maybe you're caring for an elder parent. All sorts of things can happen to make you choose to be inactive in real estate for a period of time. I'm suggesting you pay the fee. I'm suggesting you pay that $45 and stay inactive until you see what happens down the road. And again, I'm getting ready to tell you why. Failure to pay the fee means your license is expired. Okay, so a current license is the fee. Failure to pay the fee means your license is expired. If you're expired for less than 6 months, you pay the renewal fee and a reinstatement fee. So if you're expired less than 6 months, you're going to pay $90. You wake up on July 1st and go, holy crow, how did that happen? I didn't pay the renewal fee. It's all right. Call the real estate commission, pay the $90, and you're active again, assuming you've done your CE. If you're expired for 6 months to 2 years and you decide you want to get back into real estate, you pay the $90, the renewal fee and the reinstatement fee. You take 1 post-licensing class within 6 months, or you go back to PSI Testing Center and take the state exam again. Expire to 6 months to 2 years. What happens if you're expired for more than 2 years and you decide you want to reinstate your license, you want to activate an expired license? I'll see you guys in pre-licensing again. If you're expired for more than 2 years, you have to start all over. Is it worth paying the $45 fee every year? I sure as heck think so. I can't tell you how many people I've had in my class in this situation over my years. My last in-person class that I taught, I had 2 people that were there because their license expired 10 years ago. They thought they were done with real estate. You come to a fork in the road in life sometimes, and one of those directions is real estate and one of them's not. If your license is expired for more than 2 years and you wake up one day and say, I want to get back into real estate, I look forward to seeing you in my next pre-licensing class. Did I put a little bit of fear in you? I sure hope so. Pay the fee. Questions or comments on this? Is everybody good? Fiscal year is July, I'm sorry, yeah, July 1st to June 30th. Renewal period every single year is May 15th to June 30th. May 15th to June 30th is when we send in our renewal fee. And now we can go online because we're in the 21st century. How do you keep your license current? Pay the fee. An active license, you pay the fee, you've done your CE. Inactive, you've paid the fee, but you haven't done CE, you haven't done post, you're a PB without a BIC, or you just choose to be inactive. At a minimum, send that $45 in. What questions do I have about this? Okay. I think we're good. You guys have to be supervised by a broker in charge if you want to be active. PB without a BIC is inactive. So part of your application fee that you're going to submit when you submit your application, that goes towards your renewal fee. So you get your license, you've paid the fee for that year, rolled into your application. You will have to renew your first May 15th to June 30th. So if you get your license on May 14th, you have to renew between May 15th and June 30th. As a provisional broker with a BIC, PBs can do just about anything that a full-blown broker can do, as long as you're under the supervision of a broker in charge. Throughout this class, we've talked about a few things that PBs can't do. So this will be a good refresher. Tonight, we said PBs can't walk around with somebody else's money, right? PBs can't retain earnest money. If your buyer says, I'm in the throw negotiations, will you hold this check for me? You take it directly to your broker in charge. As a PB, you cannot walk around with somebody else's money. As a provisional broker, you cannot charge a fee to do a CMA or BPO. You can do a CMA and a BPO, but you cannot charge a fee for it. And as a provisional broker, you can't be a designated dual agent opposite of your broker in charge. The PB and the BIC cannot be designated opposite of each other. Pretty much everything else you can do. You can go to listing appointments. You can go to closings. You can have buyer consultations. You can make phone calls and send postcards and promote and advertise and have listings and buyers and write up contracts. And as long as you're under the supervision of a broker in charge. I told you guys I did a post licensing class last weekend. I got a girl in there. My girl's already had 7 closings since she got started. As a provisional broker, she's rocking it. She's under the supervision of a broker in charge. Questions on this? If your renewal fee bounces, if your check, well, they're not doing checks anymore, but if your credit card is declined, you're paying the renewal fee, they could have disciplinary action. Make sure you have the money on your account so that credit card doesn't get declined. They frown on that. Your application fee, when you send in your application fee, make sure that money doesn't get declined. They frown on that. Let's talk about CE, continuing education. We have to do 8 hours of CE each year, no later than June 10th. June 10th is the deadline every single year. June 10th, June 10th, June 10th, June 10th. That date needs to be up there with like your birthday and Christmas. June 10th. Here's the deal. Real Estate Commission's fiscal year, July 1st to June 30th. CE is due every year by June 10th. The Real Estate Commission has a blackout period on all education providers across the state. We cannot offer CE from June 11th to June 30th. It's a blackout period. They are in the throes of renewing everybody's license. Y'all, there's over 100,000 licensees in this state. There's like 45 people that work at the Real Estate Commission. All firms renew, all real estate licenses, schools, instructors, everybody has to renew during this time. So they do the cutoff on June 10th, and nobody, no education provider in the state of North Carolina is allowed to offer CE from June 11th to June 30th. So if you pay the fee, you paid your $45 on, I don't know, let's say you're good. You pay your fee on May 15th, the day it's due. You pay the fee, but you forget to do your CE. June 11th, you say, oh my God, I didn't do CE. You paid the fee, but you didn't do CE. What's your license status going to be on July 1st? You paid the fee, but no
Inactive?
CE.
Inactive?
That's correct. Your license status will be inactive. It's current because you paid the fee. But when you wake up on July 1st, your license will be inactive. So failure to do CE means you got about 19 days, 20 days to get your affairs together before it goes inactive. Please, please, please don't wait until the last minute to do CE. Things happen on June 10th. What if you're going on Zoom to do CE and you wake up that morning and Spectrum's down and you don't have internet? What happens if you wake up on June 10th to go to an in-person CE and you wake up with a flat tire? Please, I'm begging you, do not wait until June 10th because things happen sometimes on June 10th. And they will only grant an extension for hardships. And a hardship is not, I had a flat tire. A hardship is not, I got busy and I forgot. A hardship is like active military deployment, for example. Interestingly enough, COVID-19, they consider that a hardship. You know, I didn't know how they'd handle that. Is everybody good with this? June 10th, CE, fees due by June 30th. This is tested on heavily. This is also like your license, your professional license. I'm going to talk about that in just 1 second, Lewis. Hang on. Our CE is 8 hours. We do a 4-hour update course and a 4-hour elective. The update is the same for everybody across the state. It's the commission's opportunity to update us on current things. And I said everybody, but that's not true. Brokers and PBs do a gen up. BICs do a BIC up. Everybody does an update. It just depends on if you're a broker or a provisional broker, you do the general update. If you're a broker in charge, you do the BIC update. The elective is, and I know this sounds weird, but the elective is more fun because it's the topic of your choosing. There are so many different, I'm going to venture out there to say, name a topic and you probably find an elective on it somewhere. So whatever you're focused in, whatever your niche is, you can probably find an elective to satisfy that. Questions on this? Here's the good news for you guys. Your first renewal period, you don't have to do CE. You have to pay the fee, but you don't have to do CE. You get your first year off. The thinking is you just got out of pre-licensing, you're in post-licensing, so you probably have the current information anyway. So let's see, this is February, March. Let's just say you guys get licensed on April 15th. I'm just guessing numbers here. If you get licensed on April 15th, 2022, you don't have to do CE this year. You do CE 2023, 2020, 2022, yeah, you do CE. So if you get licensed on April this year, you don't have to do CE this year. You do CE next year. If you get licensed on April 15th, you still have to pay the fee May 15th to June 30th. Always pay the fee. But you get your first year off of CE. Is that good news? They give you that. But after that, every year that you want an active license, you have to do CE. And you're welcome to do CE your first year. They'll let you in. You just won't get credit for it. So you get your first year off. So some dates for your calendar, very important dates for your calendar. CE is June 10th. The fee has to be in by June 30th. Don't let these dates get away from you guys. I'm so serious. Back in my admin days, I was kind of the lane of a real estate school. I'm telling you guys, on June 11th, my phone was blowing up. I forgot to do CE. What do I do? Get it closed before July 1st, because you'll be inactive until you can get caught up on your CE. And the thing about CE, they don't release the new material until like August or September. Like CE instructors don't get the material. So there's a month or two. So most schools start ramping up CE again, like fall. I always do my CE in the winter. Everybody says we're slower in the winter anyway, so I knock it out during the slow times. So I don't have to worry about it when spring market rolls around. I'm done with CE for this year. So that's kind of a good feeling. Post-licensing, we got 30 hours, 90-hour total post-licensing. You have to complete all within 18 months of your licensure. Whatever's your anniversary date on your license, that starts your 18-month clock. Every single one of you will probably have a different date. Again, they may grant an extension for a hardship, active military deployment, COVID-19. But I got busy and I forgot is not considered a hardship. So don't let this 18 months get away from you. If you don't do your post-licensing within 18 months, your license will be inactive until you do get it done. And they are not going to remind you of this. They're not going to send you postcards or mailings or anything. That's up to you to get your post-licensing done in 18 months. What questions do I have? No? Everybody good? When you think of them later, know I'm around. Don't hesitate to reach out to me. I'm here. Okay. License law and commission rule weighs in on timeshares. They regulate timeshares. Unless you're going into timeshare development, we just need a very basic understanding. You guys remember this? You want to do it with me? Ready? You want to do it? 5, 5, 5, 10, jazz hands. What do we need to know about timeshares? The definition of a timeshare is the right to occupy a unit during at least 5 or more separate time periods over at least 5 years. Please note the words at least. That means 5 is the minimum. So if your test says 10 separate time periods over 10 years, that's still a timeshare, right? Because it's at least 5. So 5 is the minimum. The buyer has a 5-day period to rescind their timeshare contract. They take their contract back as if it didn't exist, get back any deposits they put down. The timeshare developer has to keep the deposit in their escrow account for 10 days or until the contract is rescinded. And this is the only time that the Real Estate Commission can fine a licensee is a timeshare developer, and they can fine up to $500 per violation. I feel fairly confident if you get a timeshare question, it's going to be based off of this. The syllabus does cover a little bit more information on timeshares. We're going to go through it like super fast so we satisfy the requirements. But this is what I want you guys to get. 5, 5, 5, 10, $500. So let's briefly go through. Article 4, don't need to know that. Article 4 is about timeshares. The Real Estate Commission says the timeshare salesperson has to be licensed. They have the same license law and commission rule that we do. And each timeshare project has to obtain a certificate of registration. They have to register the timeshare project. They register it with the Real Estate Commission so they can manage it, so they can regulate it. Failure to regulate the timeshare project, the developer could be found guilty of a Class 1 felony, fines and jail time. So timeshares are registered so the Real Estate Commission knows they're there and they can develop them or regulate them. Turn real quick with me, page 596. 596 has timeshare definitions. Page 596. These are the ones that we need to be aware of. The developer is the person or the entity that creates the timeshare. Each timeshare development has to have a project broker. When you see the project broker, think about the designated broker in charge. They're supervising the timeshare, the day-to-day operations, the salespeople, any unlicensed employees. So when the project broker is pretty much like the broker in charge of the timeshare. The timeshare itself is the right to occupy at least 5 times over at least 5 years, or 5, 5, 5, 10. The timeshare instrument is the documents involved. The contract documents are going to record the timeshare, the deeds. The timeshare salesperson over on page 597 is the individual broker who's selling the property on behalf of the timeshare developer. And then the unit is the dwelling, whatever it is that we are occupying for our 1 week out of the year. The developer has to record the timeshare instrument no less than 6 days nor more than 45 days following the execution of the contract. No less than 6, because if the buyer rescinds, they have nothing to record. No more than 45, because we just don't want it lingering out there. So timeshare instruments are recorded no less than 6 days or more than 45. Timeshare developers have to follow the same trust account, escrow account that the rest of us do. So they follow the same trust account rules that we talked about. There's no difference. Timeshare developers follow the same trust account, escrow account rules that we do. Timeshare developers have to offer a public offering statement. They have to offer a public offering statement to the public. And this tells the public who's managing the timeshare. What are the fees? What are the costs? What's it about? What are the rules? Article 4 is also what addresses the purchaser's right to cancel. So Article 4 says that they can cancel within 5 days. All they have to do is provide written notice to the developer. The developer has their deposit in an escrow account. They have to keep it in the escrow account for 10 days. If the developer fails to provide the public offering statement, they have to give the purchaser 10% of the sales price. So there's incentive to the developer to provide their public offering statement if they terminate, if they cancel. Timeshare developers, salespersons, and project brokers are subject to the same disciplinary action as the rest of us, with the exception that they can fine the developer up to $500 per violation. There's no difference there. Any penalties of the timeshare developer could also be class 1 misdemeanor. Timeshare developer can be fined. It's basically what we're saying here, not just by the commission, but by the injured party if they get sued. Timeshare developments have one person that's selected as the registrar. The registrar is responsible for recording the timeshare deeds, the timeshare instruments. So you have one person responsible for recording that. Developer designates who that person's going to be. Maybe it's the project broker, maybe it's themselves. But one person's responsible for recording the instruments. Each location has a project broker. Again, think about the broker in charge. That project broker is responsible for supervising all the activities in that timeshare development, just like the BIC is. How long do you guys think timeshares have to retain their records? Yeah, they follow the same rules that we do. So they keep all records for 3 years. By the way, section 58B, again, you don't have to know this, but we've switched to commission rule now. So there's license law and commission rule that regulates timeshares. Don't need to know the numbers. Just put them there so you know I'm legit and I'm not making stuff up as I go about this. Same rule as a trust account. Have to deposit more than 3 days. Have to remain in the account for 10 days. Again, same rules, trust account, escrow account. Provisional broker can't be a timeshare. Project broker. PB can't be a PB. Provisional broker cannot be a project broker. Project broker is responsible for reviewing contracts and the public offering statements. They regulate their employees and make sure that unlicensed employees are not acting as salespersons. And they too have to notify the real estate commission within 10 days of receipt. I'm sorry, 10 days of a name or address change. So pretty much the same. Again, we went through that super quick, I know, because the syllabus told us to. So I've satisfied the criteria. I try to do what I'm told. What do I think you're going to, if you get a timeshare question, what do I think you're going to be tested on? Let's do it again. Let's all do it together. You ready? 5, 5, 5, 10. Okay. If you see a timeshare question, that's our license law and commission rule. There is no key terms, but in your book, let's turn to page 729. The key point review on 729 is a very nice summary of everything in Appendix A. Appendix A is a couple hundred pages long. So use the key point review to help you focus in. Again, what we talked about are testing topics. I made sure I covered everything in the syllabus. And there's a really good student quiz for Appendix A on 737. So let's talk about your state specific exam. So there's the national section and the state section. My exam is it's one test, but it's broken up into 2 parts. State exam is 2 separate parts. Like my test is one big run on. There's a national section, state section. For your state exam, you get graded on each, a grade for the national and a grade for the state. So to get your license, you have to pass both sections. To pass my class, you just have to pass the whole test. State specific questions mostly are coming from license law and commission rule. But don't forget, you guys, I think one thing as you're studying, please make sure, kind of scatter throughout your book. And I'm just going in my book and I just opened a random page. I just turned to page 506. Totally random page, 506. You guys see in the left-hand margin where it says in North Carolina? That could be a good candidate for a state-specific question. So as you guys are studying, as you guys are getting ready and going through this material, When you see in North Carolina on my PowerPoints, when you see our state flag, that could be the difference in a national topic and a state topic. So the national topics are those topics that all of us, no matter what state we're in. States topics are those that are specific to us here in North Carolina. Typically, what happens statewide? When students go to PSI Testing Center, it's not uncommon to pass the national section, but fail the state. It's not uncommon. And I think a big reason for that is because the state specific section, specifically license law and commission rule, is so detailed. It's very precise. You don't only have to know it, but you need to know it really well. So please make sure you're focusing on that state specific stuff for both to get through my exam and of course the state exam. In your book, if you guys will please turn to page 819. There's a comprehensive exam. Good culmination of everything. Also in Learn, Test, Pass, there are 2 comprehensive exams in the 100% material. There's a 100% exam. You guys, if you've been going through Learn, Test, Pass, there's a 25% exam, a 50% exam, a 75% exam. Now we have a 100% exam. And then there's also another final exam for students, flat PDF. So there's 3 comprehensive exams for you guys that you can use to gauge yourself. If you get something wrong, this is your opportunity to look it up or call me. You guys remember how to grade yourselves? Hopefully you've been gauging as you go. Remember, we get to use the T-bar to grade ourselves. So once you take these the exam in your book and the flat PDF, take the number you got right and divide it by the total number of questions. That's going to give you your score. Remember, for my exam, you got to get a 75% or better. So as you're going through, I know this weekend is your cram weekend. As you guys are going through and studying, make sure you're grading yourself as you go. You're going to be weaker in some units than others. So make sure you're gauging yourself. Number you got right. That's a generational thing, isn't it? Guys, we're done. I'm not done tonight, but we're done. We've been through everything, which means you guys have a whole week to put it together. I'm amazed with how we got through this class. So this is what's going to happen between now and Wednesday. Yes, you have to make a 75% on my exam. So tomorrow you guys are with Ann. Please go to Ann's Zoom link tomorrow. She's going to do a review for you guys. I have no idea what that looks like, but she's going to do a review for you guys. Tuesday, when we come together, I still need to do safety. We're going to do safety on Tuesday. We got a Kahoot. We got to do our license law and commission rule Kahoot. So we'll Kahoot, we'll do safety. We got to do our rules and expectations for my exam next Wednesday. So we got to make sure we're all clear on that. Again, Tuesday's a class day, so please come, if nothing else, to hear the rules on the exam, right? I'd hate for you not to know the rules and lose your test. So, yeah. And after that on Tuesday, I'm just opening it up for a Q&A, a free-for-all. So If you don't want to reach out to me this weekend, you can bring your last minute questions on Tuesday. We'll do what you want to do, math, you want to do, whatever. So, feel free to reach out to me this weekend. I'm around. But you guys don't forget too, when you're doing the math, I mean, here's end of course review for my exam. So use this as your study guide to know what to look at. And then when it comes to the math, here's the math you can expect to see on my exam. So if you want to just focus on next Wednesday, here it is. Get you one step closer to that state exam. Yeah, Danielle.
Do you have a particular date that you're cutting off personal tutoring?
No, but it's going to be, reach out to me if you want tutoring. Our schedules are full between now and then. But reach out to me if you want tutoring. Absolutely will. It might be a 6 a.m. session or something, but we'll we'll do what we can. But yep, just reach out. We'll figure it out. What do you guys think? How's everybody feeling? Y'all know what I know. There you go. There's everything I know. Have that. I just saw you guys relax for the first time in 2 months. You guys just exhaled for the very first time. So I still need you to come to class tomorrow. I still need you to come to class on Tuesday. But you guys are in a great position to put this all together, fine tune it, ask Julie questions, review with Ann tomorrow. Thoughts, comments, concerns? You guys are so quiet tonight. I'm concerned about how quiet you guys are. That's my concern. Y'all just taking it in, I know. Okay. Y'all have a great weekend. Have fun with Ann tomorrow night. Have a good time with Ann. She'll help you put it all together. Don't forget your cram course on Saturday with Jane. Again, she can help you put it all together. I will see you guys Tuesday. Is that right? Yes. I will see you guys next Tuesday night. So y'all have a good weekend. If you need those links, just let me know. It just got real, didn't it? I hear you.